My name is Equitable Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public. So please subscribe to our channel. I want to talk today a little bit about prenuptial agreements. Prenuptial agreement is an agreement that the parties sign in an effort to establish what is prior acquired property that is not subject to division and what would be marital property subject to division. The idea of the prenup is, I got stuff, I accumulated before, if we're getting divorced, I want to keep my stuff. I don't want it to be part of the marital estate. That's the idea of the prenup. Now a lot of people will complain, I don't understand. We got married. I had him sign a prenuptial agreement and now I see in the divorce papers they're asking for everything. How can that be? Well, you have to understand something. The law, particularly the law in Michigan, is not Hollywood. In Hollywood, you have movies that talk about prenups that are the subject of, at least mentioned, if not the subject of the movie, at least mentioned. There's a movie with George Clooney, Bonfire of the Vanities, where they talked about he was this lawyer and he had supposedly this iron-clad prenup. Couldn't be penetrated. The truth of the matter is, in Michigan, there's no such thing as the Massey prenup. There is no iron-clad prenuptial agreement that cannot be penetrated. The law here allows the court to do what equity requires. Now, the court, because a prenuptial agreement, assuming it's a binding contract, that it's not done under duress or any of the equitable remedies, assuming that the agreement is valid, it's a contract, the court will do what it can to uphold the contractual relationship between the parties to support that contract, but at the same time, the court is obligated to make an equitable division of assets, which may mean that the court, for whatever reason, might find that all or some of the prenuptial agreement is not going to be enforced. So we always tell people who ask us to write prenuptial agreements, we always tell them, look, you need to understand one thing. The agreement is what it is, but the court can find for all sorts of reasons that it wants to invade the agreement. I'll give you an example. A valid prenuptial agreement will require that the parties disclose all their prior acquired assets and give reasonable, appropriate values for that. It will require the parties to sign the prenuptial agreement and have it in hand sufficiently in advance of the wedding, so that they have time to review it, time to maybe bring it to outside counsel, time to hire a lawyer to negotiate on their behalf, all these things. So, worst case scenario, if somebody hands someone a prenuptial agreement and said, here, sign this before we get married tomorrow, the prenuptial agreement says some assets, doesn't give any values, so the person doesn't really know what they're giving up because they don't know the value of these things. Plus, they haven't had time to have it reviewed by counsel. They feel pressured to do it because the wedding's tomorrow, and God forbid if I don't sign it, the wedding might be called off. Don't want to do that. So all of these things compel somebody to sign this. Was it fair that under those circumstances they should be held to that contract? Don't be surprised for the court to say, you know what, I'm not upholding this. It wasn't done under appropriate circumstances. So the court, while it will try to enforce the contract, the court may find that there's invalidity in that contract, all or in part. So therefore, when we talk about these things, don't be surprised if the presence of a prenuptial agreement doesn't nonetheless result in somebody filing and asking for a bunch of stuff that maybe you thought was already covered in the prenup, because they have at least the right to go before the court and say, you know what, yes, it's in the prenuptial agreement, but the values are wrong. I didn't understand what I was signing. I didn't have time to have it reviewed. Or the equity of the circumstances supports the agreement only in part, but doesn't support it 100%. They have the right to argue that. And of course, your lawyers will know how to respond to it. But remember, we do have a system that allows people to ask, even if the answer is no. If you have any questions about that, reach out, and we'll be glad to help you out.